Hello. Good morning, everyone.
Good morning.
Rosemary Laverty. I am the current president of Crew Philadelphia, and I am a partner at Dilworth Paxson LLP, which is a regional law firm, multidisciplinary, and we're going to have my partner Jen Snyder speak to us today. So before we do our own intro, I'm going to have everybody introduce themselves, but before that, I need to thank our sponsors. So I'm going to share my screen for a minute, and I hope that you can all see the, can you see the slide?
Not yet.
Slide.
Ah.
The sponsor slide, is that now showing up?
Yes, it is.
Okay. So I just want to thank our annual sponsors, our premier lead, Bercadia, our skyscraper sponsors, Dilworth, Wisfis Bank, Brandywine Realty Trust, White & Williams, First American Title Insurance Company, Capstan, KSS Architects, Sonero, Herman Miller, and Target Building Construction. Our high-rise sponsors, Skanska, Spectrum, Fox Rothschild, NFI, J. Davis, O'Donnell and Nacarado, Brookfield Properties, Fidelity National and Chicago Title Insurance Company, Irwin and Layton, Archer, Clemens Construction Company, Elliott Lewis. Our groundbreaker sponsors, Equus Capital Partners, Greyhawk, Hayworth, Land Services USA, NV5, Bach and Clark. And our affiliate sponsors, Advantage Sport and Fitness, Court, Interface, Rethink Innovations, and Trans-American Office Furniture. So thank you. We couldn't do it without our sponsors. Now I have to figure out how to unshare my screen.
Seems like we have a lot more sponsors. Is that true, Rosemary?
I think it's probably about where, oh, there's Sarah.
I know, I figured I shouldn't be so rude.
Thank you.
I got to a good stopping point.
Well, our sponsorship committee, well, now it's the corporate engagement committee. They work very hard. I think we're all going to be challenged with finding sponsors for certainly the balance of this year, and who knows what next year is going to bring. But we will all continue to work hard, and we're hoping that we bring some value to members and sponsors. So part of what we're trying to do going forward in these events, virtual events, is give our sponsors the opportunity to either host an event or come up with an event. So I am pleased that my partner Jennifer Snyder in our labor and employment group has agreed to share her experience with what she's seeing given the situations with the new laws and everything involving employees. So I'm going to ask Jen to introduce herself, and then I'm going to ask, I'll go across my screen, ask each one of you to just tell us who you are and what you do. So Jennifer.
Hi, everyone. Thank you, Rosemary, for inviting me. It's nice to meet all of you. I specialize in labor and employment law. I'm a partner at Dilworth Paxson, and I've been practicing in this area for over 25 years now, which is really scary. And throughout my career, I represented employers and their executive teams in every kind of labor and employment issue you can imagine. I represent employers in negotiating with unions and all the traditional labor management relations issues. I represent employers in every facet of discrimination and retaliation and leave policies, which is really the hot issue right now. And basically both developing policies, helping to guide employers in enforcing policies, defending litigation, pretty much the spectrum of issues. I also work with employers and executives on non-compete, non-solicit, non-disparagement, confidentiality, trade secret issues, and I'll do a lot of proactive training and counseling. So I have been really busy through this pandemic, probably busier than if I was actually doing normal work in the office. I feel like I've been running a marathon at a sprint speed for the last 7 weeks, and it's been really odd. At first, it was sort of energizing to know that my world, at least work-wise, had not fallen apart, but it has created unique challenges as we've continued through this, and I don't really see it ending anytime soon. So I look forward to meeting all of you, understanding a little bit about what brings you here today and what you're interested in, and hoping that I can address some of your questions.
Okay. Allison?
Good morning, everyone. I'm Allison Christopherson, and my company is Rethink Innovations, and we do corporate audio-visual video surveillance and access control. And our usual client is moving into a new space, and then we help them with their fit out. Are we supposed to touch on what, or just introductions, or do you want to touch on what's affecting us?
I'd love to hear what's affecting you.
Yeah. Sure.
Okay, so fortunately, I've been able to keep my staff. But we're a smaller company, so it's easier to hang on to 6 people than it is 60. So I'm just curious on like what the future is going to hold. God forbid we don't get back to work by the time we think we're going to.
Great.
So.
Frank? Frank?
Oh, I'm sorry.
Yep.
Frank Gallagher with the FGX Group. We are owner representatives, project managers. We do renovations, building additions, and ground up construction. We do our work within the tri-state area. For the most part, we like to stay within a 2-hour or 3-hour radius of greater Philadelphia. That being said, we do have some out-of-state projects as well. We will travel for the right client, for the right project types. Our commercial vertical pretty much is fairly diverse. That being said, we do concentrate highly on healthcare, corporate renovation work, K through 12, higher ed, a little bit of retail, manufacturing, and industrial, a little bit of mixed use and multifamily as well. Thanks, everybody.
Great. Thank you. Carla?
Hi, I'm Carla Driver. I'm the Director of Special Projects and Services at Trans-American Office Furniture. So in my current role, I am interested in this conversation both to kind of be a resource for our clients, but also I've just gotten more into, the leadership team, and this has been my first foray into tough conversations for employees. We've been really lucky to have secured a PPP loan, and hopefully that will help us, not have to make any adjustments, but just interested in, what other companies are doing. And even from, the return to work perspective, what can we ask an employee about, how they've been quarantined and things like that. How do we talk to people about coming back, and what's appropriate for us to be able to ask people?
Okay. Sarah?
Hi, I'm Sarah Anderson. I just went through this, actually. I was laid off from Avis & Young, where I was a senior project manager. We're owners, reps, and project managements, manage projects, and so on. I was laid off on April 3rd. One of my clients was very dismayed about that I had been working with solely, and they created a position and made me an offer 2 days later to be their project manager of property. So I'm going to be managing their design studios. It's Glengarry Corporation. They're a brick manufacturer. They were bought by Brickworks Australia, who is a large building products company. The branding is so drastically different. I mean, what I say, Brickworks makes brick sexy. They've got like amazing products, and they're just a really design forward company. So I'm going to continue to manage their design studios, of which we're doing 2 right now, one in Philadelphia and one in New York. And yay, we're getting started on Monday with Philadelphia again. New York still not so much, but they will be doing others. And then also Masonry Design Center of the Future. So I'll be overseeing that. And then there's other things going on with properties that I'm working on. But anyway, I was interested in this. Primarily, I think I had submitted a question because I still have all of my personal belongings at my office. And of course, they took the tact, my former employer, of, we'll pack your stuff up and send it to you. And I was like, no way. So I was wanting to know what they were able to do, although since I submitted that question, they reached out to me and arranged to arrange a time for me to come and get my things. But I still would want to know what they're able to do and what they're not able to do. And then, of course, I have to make sure I signed a severance agreement that I did have an attorney review. you know, all this stuff has actually worked much more smoothly than I thought it would, but I have to be really careful about disparagement and maybe even trade secrets, but I can't even imagine what that would be, you know, because there's only one thing that comes to mind that certainly I can't discuss, but, you know, other than that, you know, we do what we do. I mean, I thought I was actually going to be reaching out to Frank because I thought originally the client was going to offer me a contract position. And if they did, I was going to start my own business and talk to him about how to get going. But they created a position. So now I'm just an employee, not just, but I'm an employee again. I'm excited about it. But the other thing that just came up for me, and I don't know that you know anything, that you have thought about this, Frank's probably thinking about it, but in the design studios, as we move forward, there's going to be a lot of things that spaces are going to require for no touch. And, you know, I would think that that might overlap a little bit into your area, like what are employees going to require? And I don't know what you think, if you have any ideas on what you think is going to be required or what you recommend. I want to try to plan that into my projects as we go forward.
Great.
Okay. Kathy.
I think I pretty much know everyone on here except for Jennifer. Hi.
Hi.
Kathy Fay. I am the Director of Business Development for Irwin and Layton. We're a construction management firm based in King of Prussia. And I am on the board with Rosemary of Crew Philadelphia. And I just kind of wanted to, you know, as you mentioned, or everyone probably has, you know, now we're just about through week 7. And I have not been having a ton of contact with the people in my office. So we've been very lucky in that most of our construction has been able to continue because a lot of it has been in New Jersey. Our Pennsylvania jobs, of course, are able to start up again Friday. So just kind of listening in as to what people are doing moving forward so that I can perhaps come back with a couple of pointers for my team as we're moving through the next, what have you,
Great.
piece of this.
Marinella. Hello.
Hold on. Oh,
I unmuted you.
hi, I'm Marinella Abel. I am the events co-chair for Crew Philadelphia, and I am currently unemployed, which kind of seems like a blessing in disguise at the moment. I have 2 little ones to take care of, one with special needs. So, so it really, it's quite crazy that I feel like that, but it helps. And Crew keeps me busy. I enjoy it a lot. So I kind of seen a lot of you. You guys heard this spiel already. So, hi.
Hi.
Sorry I was late.
We have one more person who's connecting to audio, Shelby, but it still says connecting to audio. Okay. Once she connects to audio, we'll have her introduce herself. So,
Shelby looks like she's where I want to be right now.
yeah,
We all want to be there, right?
I know, right?
Especially on this dreary day.
Oh.
yeah.
Kathy.
So Jen, do you want to?
Yeah, I'll just jump in. So I think all of us feel like, I think we're all realizing that this is not a temporary impact to our worlds, right? But things that we really took for granted as the way we operated 8 weeks ago, it'll be a very long time before we go back to that, right? I think back that I've been in my house since March 12th. I've left for a couple of walks around the block, but pretty much have been here since. I had one of my kids have been sick on March 12th, so I was like, well, he has a stomach bug. You know, didn't seem COVID related, but I'm obviously going to stay home with my kid and, you know, handle work from home. And then the next day, school started closing. So I was like, okay, I guess this is going to be my new normal. And then before long, offices started closing, and we realized that this was not going to be a 2-week pause in our worlds, right? I think all of us could have mentally handled that. And as the time has extended, it's required a really big mental shift. And there's a lot of answers out there. There's a lot of new laws. So in the span from March 13th to now, there's been 2 massive pieces of federal legislation that impact employers. There have been changes to Philadelphia laws. There have been orders put in place by the Pennsylvania governor and Department of Health, Secretary of Health. For those who work in New Jersey, there's been there's been a litany of orders from both the governor's office as well as state laws that have been changed, expanding leave rights and how you earn time off. And so for the first few weeks, keeping up with all the legal changes and thinking about how this was going to work in a climate where certain businesses are not even allowed to operate in person was just a lot to get our heads around. Now, I think we've come to there's a lot of people who have been laid off because either the revenues have not been there because operations can't go on in person. And frankly, I've even confronted the situation with employers where employees have been furloughed or laid off temporarily with the expectation to come back April 3rd, May 1st, something in that range. And then having employers worry about how are they going to get employees back to work if they're earning more on unemployment given the stimulus checks, right? Mm-hmm. And so I can talk about those implications as well. I guess if we want to maybe start with trying to address some of those questions, and I think I remember at least most of them, but if I'm not talking about something that you want to hear more about, just pipe up. I would really want this to be a discussion roundtable, as if I understand you have lunches from time to time. I brought my, Bonjour coffee mug, so that I've had since I was 10 years old. And, I really I appreciate you welcoming me here today and want to help you get whatever information would be useful for each of you. So, Sarah had sent the first question, and so I knew about that one ahead of time about packing up your personal stuff. And generally speaking, most employers say, if you bring something onto our workplace and store it in our property, whether it's desks or office space, then we pretty much have, there's no right to privacy. So the only limit, and that more typically extends to spaces, for example, where use of computers and issues come up with what computer images or data employees can get back after employment has stopped, right? Because usually most employers have policies that says, if you put it on our computer, it becomes our property, and be careful not to do that. But really, once we have it, it's up to us what we do with it. And personal property, physical property is a little different, but generally speaking, most employers could take the position that we're just going to pack your stuff up. I have represented both employers and those navigating those issues and executive employees who have personal items of value in their spaces and had a sudden employment change that didn't allow them to get back in their space, and have negotiated out, having opportunities to pick things up. If it was someone who the employer considered disruptive or problematic, that can often be a more complicated negotiation process sometimes than, even the amount of severance someone's being given. So I'm glad that you were able to negotiate out, a way for you to pick up your items in a way that made you comfortable. But generally speaking, most employers could take the position that they could pack their stuff up. Okay. You also touched on signing a severance agreement and non-disparagement and trade secrets and things like that. I'll just touch on that for a moment because I'm working with a lot of executives right now. in some ways having nothing to do with COVID, but nevertheless going through those kind of transitions. And those are commonplace prohibitions that are put in agreements. I will just flag for you that confidentiality and restrictions on, talking about or using information that you got on the job as a general matter is sort of a commonplace post-employment restriction. It has been used by employers to try to stop employees from engaging in competition, or even if they don't have a non-compete obligation. So really the issue is, what's the sensitive information that you know only as a result of being employed by that company that isn't generally known on the open market? Is it pricing, profit margins? Is it certain supply chain preferential treatment? Is it certain timing issues that Is it client relationships where so much information about a client that couldn't really be known publicly? Okay, those are the kind of deep information dives that you could only know by virtue of having worked for a company and have them financed to support you developing relationships or developing this knowledge base, that could be at issue if you are in a role at your new company that somehow using that information, even if it's not disclosed, could put the new company at a competitive advantage and the old company at a competitive disadvantage. Does that make sense?
Yeah.
Great.
Because I'm two different ones, so
I just wanted to give you some general pointers, okay. I know there was another question raised about just generally thinking about the return to work with design studios and what that's going to look like. And, it's funny, I just participated in a seminar yesterday speaking about return to work issues and how are we going to now transition back. And I could spend not only the next half an hour, but like days talking about all the considerations, but I'll give you some sort of bullet points. And I do really want this to be an interactive discussion. So if something I say prompts someone to, want to jump in and ask for a follow-up, please do. So I think as an employment lawyer, my thing I'm trying to stress to my clients all the time is the benefits of productive and thoughtful communication. Like, none of us, as humans, we don't operate well, in silos. Even the most introverted people still need some kind of human contact, right? And presuming that everyone is on the same page when there's not been communication is setting any organization up for failure. I'm not saying to over communicate. I'm just saying be thoughtful. And, I've had clients think about, is this a time to reach out to employees to measure how they're coping with the pandemic and working from home? And, while the idea came from a great intent of wanting to make sure that the employees felt that there was two-way communication, at the end of the day, the question then becomes, well, what are you going to do with this information? What if you find out information about employees that you really don't have a way to help them with? How has that advanced the ball? And again, depending on the size of the organization, the nature of the organization, those are all reasons why you do or don't go ahead with something like that. But that was not a consideration that the client had just been sort of sold on the idea of let's take the temperature of all these employees. And I'm like, well, once you have that information, don't you think you should be asking for it so that you can help them in some way? If you're going to direct them to resources, great. If you're going to come up with policies for when we return to work, but you're having challenges dealing with childcare, are you going to create some flexible policies to address this one moment in time? So every type of communication should be with an intent of either sharing what the company's going through, what leadership is going through personally, what employees are going through, but with a goal to be able to move the ball forward, whether as a team building or as a, here's how we come back. Okay. I've had clients think about, to the extent that we're starting to come back, even when return to work orders, stay at home orders rather, are lifted, does it make, just because we could go back to our office or just because we can go back to physical work, does that mean we should? Or how is that return to work thought through? Are you doing staggered returns to work so that if, God forbid, people get sick, you haven't lost every critical member either of your executive team or people with certain specialties, right? IT is a perfect example, right? Our firm, for example, has a rotational schedule so that people with critical skills that allow all of us to work still are coming in person on a rotational schedule, so that if anything, unfortunate happens to any one person, we haven't lost our entire bench, right? And across all organizations, that's a consideration to make. So to the extent that you've been able to work from home and work from home effectively, then maybe this is not the time to say, come on, rush back to the office, back to, the way we always did things. Maybe it's a time for, when you bring people back, how do you also decide who comes back when? Is it random? Is it based on volunteers? Is it based on some kind of identified need where some type of work can only be done well in in a physical space, as opposed to virtually? Is there thought of how, one suggestion I've heard, and I think is a good one, is doing sort of a dry run walkthrough of physical spaces before you're going to both invite employees and customers or vendors back into them. So you can think through, I think the issue was raised about surfaces, are we going to have certain surfaces that can't be touched? Or are we going to do we need to put up certain banners or ropes, like this is not for touch, this is for touch, and then have certain protocols put in place for, cleaning protocols, or setting expectations, what expectations are put on employees themselves, what additional safety measures or precautionary measures are companies thinking through to retain extra cleaning services or to impose other means of safe workspaces. Where's the division between the shared obligations, really, to keep everyone healthy and safe? Because the last thing I think any employer wants is to bring people back to work with a thought that we can get back to normal or try to, jumpstart revenue generation and then set ourselves back, another 6 to 8 weeks, right? So another question I've been getting is, to the extent that you want to bring people back, but you don't have full-time work for them, and they were previously classified as exempt from overtime under wage and hour laws, but you'd like to bring them back on, let's say, a 20-hour per week schedule or a 10-hour per week schedule as like a skeleton work schedule, but not full-time work. There's a lot of considerations about changing classifications back and forth from exempt to non-exempt and creating obligations for tracking hours and overtime pay. So that's certainly something to be thinking about. What would a schedule be? And what's a justification? I would think that for my clients that ask me to do a full-scale audit of their company and how do they come back to work, and I'm working with several clients on this, think through why each person physically needs to be back at work, what their role is and how they need to contribute and whether they can be contributing remotely. I think that the challenge is for the people who really do need to be in a physical space and then the question is going to be, is it because of customers, and are customers going to even come given the current state of the world? And so I think all of those are issues to, before you start bringing people back to work, how we do it shouldn't be just a guess. It should be something that whatever team of or individuals are in charge of deciding who comes back when and what projects got started for construction work. I know someone mentioned that, construction projects in Pennsylvania can start end of next week. New Jersey's been able to be ongoing. But even on construction, and I have real estate clients that I work with, even on construction projects, there's going to be expectations that employees are still social distancing to the greatest extent possible and wearing protective gear, and that no more people are on a project than absolutely need to be at any one moment. And that to the extent feasible, I think both federal and state agencies are going to be auditing and monitoring these practices. And I think that there's also a high risk in terms of risk management, that employees who feel like employers are not taking appropriate steps to protect them are going to be making whistleblower type claims. In New Jersey, that's super easy because every employee, whether they're public sector or private sector, are covered by the Conscientious Employee Protection Act, which is a very powerful state law that protects employees against retaliation for reporting unsafe conditions that impact the public. And obviously, with the impact of COVID-19, I think that any employer engaging in unsafe work practices, as far as not keeping employees protected to the extent that they think is required, noisy employees will always come up with creative claims. Lawyers who represent individuals in those kind of claims are going to be looking for creative angles, and I think that's certainly one of them. In Pennsylvania, there is also a whistleblower law, but it generally applies to either public sector employers or private sector employers who accept public funds. So a question has been raised, well, if you get a Paycheck Protection Program loan, or if you benefit from the CARES Act in some way, does that mean you're accepting public funds? There's not a clear answer to that yet. I don't think the answer is yes. Maybe if the loan becomes a forgivable loan, then you have accepted public funds. So that, I think, answer is still open for debate. But I just flag that as an issue. There's going to be an uptick as we come back to physical presence in whatever work we do. There's certainly going to be an uptick in employee complaints about the way we're doing it and second guessing a lot. Right now, the debate in Congress, as far as the next stimulus bill goes, is between pushing for more monies to state and local governments versus, creating certain protections or safe harbors for employers who do engage in protective measures but can't 100%, guarantee that their employees won't get sick. So there's a debate raging about how much protection employers can get for doing at least what a reasonable person in their circumstance would do. Okay, so I think all of those are considerations to have as you're coming back to work. But I'll go back to you all. Do you want to throw open some other questions?
So Jen, if someone is, let's just say, an essential worker, but they have a situation, maybe not themselves, but they live with someone who's immunocompromised, who's elderly and has a lot of health issues, so they just aren't comfortable going to work because they're afraid they're going to bring something back home.
Right.
What can an employer do? Can they force that person? Can they fire that person? And what?
Thanks for asking that question. I've actually given advice on directly that situation.
How about that?
I have a lot of clients in the healthcare industry where virtually all employees of healthcare organizations could be classified as essential in that their companies or organizations are engaging in life-sustaining operations in, at least in Pennsylvania, that's the standard. It's a little bit more flexible in New Jersey. But I'm going to focus on Pennsylvania. And I had one client have an employee who they deemed essential, who, and this employer, let me just preface it by, has put up face guards, you know, so that at desks, so that they're to minimize contact, even if someone has to talk to someone over a counter type desk, that there be minimal physical, there's a physical distance put there, right? Physical barrier. They've brought in lunches individually wrapped for all essential workers who are coming into the office every day. So they don't have to go out of the space. They can, you know, they don't have to use a cafeteria that's open to a group of people. They can have food brought in and know that it's, you know, tailored for them, right? There was this one employee though, who took public transportation to get to work every day, said she didn't feel safe on public transportation because her mother was immunocompromised and she lived with her mom. The employer offered to pay round trip for her to take Uber or Lyft every day to work. The employee said that didn't seem safe either. The employer let the employee take some paid sick time to take days off. They had already also instituted a rotational schedule, so not everyone was coming in at the same time, not everyone was leaving at the same time. They did create some rotation, so some people didn't have to be in the office every day, but nevertheless, most of them had to be there every day. And they were also concerned about setting a precedent. Once they let one person not come in because of a fear, then that's going to have a trickle-down effect, right? So I said, let's go back to basics. Pre-pandemic, if an employee presented and they said they had a fear of coming to work because of living with someone who's immunocompromised, arguably, if that fear was deep-rooted enough that they could get a doctor's note to say that they had anxiety that required them to have a leave of absence for a period of time, then they might qualify under the Family Medical Leave Act for protected leave. The job has to be held open. They wouldn't get pay unless they had PTO banks of time available that would run concurrently with the leave. But that would be one option. Relatedly is if a doctor would write a note for the employee saying, you need to be here to take care of your immunocompromised family member during this period. And because of the pandemic, that person, although able-bodied, you know, can't go to the grocery store, can't go here, can't go there. So they need you to basically help them sustain their life. And so that would also be a potential way to get family medical leave covered. And that's pre-pandemic standards. Under the federal Families First Coronavirus Response Act, which was the first big piece of federal legislation passed at the end of March, employers with up to 500 employees, those employees could seek leaves of absence, whether to take care of their own health condition because of COVID or a family member's condition because of COVID, but just being immunocompromised without actually having symptoms of COVID is not a protected reason for leave under that act. That act also allowed employees to take leaves, and again, these are all partial paid leaves. These are not unpaid leaves the way regular Family Medical Leave Act leave was. The additional leave was to take care of children who either have an interruption on either daycare or schools because schools are closed. Again, this employee didn't have kids, so that wasn't even a consideration. There's also an exception in that law for healthcare related employers and their employees that it makes it a higher burden to be able, and an individualized inquiry is required to figure out whether a leave should or shouldn't be granted. But for right now, let's presume none of those new federal standards were implicated. The other potential, basically we came up with the answer to the employee is you can take some paid leave up to a week or two, I think is what we decided. And then after that, we're not going to let you take a general unpaid leave of absence. If you come in with a doctor's note that substantiates a leave reason that we can tie to some obligation we have, we're going to hold you to those standards. But we can't just let you not come in because of your fear of coming to work and because you live with someone who's immunocompromised, because that doesn't fit into any of the rubrics. And while under the pandemic standards and under all the advice that myself and other employment lawyers are giving, this is a time to be flexible with employees. It's not a time for the tail to wag the dog. Because the first time you let an employee not come to work for an extended period of time because of their fear, no one's going to show up. And if it is truly an essential life-sustaining business, and that, you know, also requires that inquiry, if the work could be done remotely, then it should be done remotely. I've had clients in non-life-sustaining businesses, but that could operate during the pandemic because they were defense contractors, or they somehow were able to get into an exception of the governor's executive order shuttering down businesses, right? But the employees were managing supply chains and doing other work of that nature. The work could largely be done from home and they had set up systems to do that. The head of the office in Philadelphia, in the Philadelphia suburbs, didn't like the idea of remote work, didn't want to set a standard, didn't want to set a precedent, and frankly liked the idea of everyone coming together. And the advice I gave is, well, that's all well and good, but if the work can be done somewhere else, then only really critical work that has to be done in person should be done in person. And I've had to write letters for employees of businesses to make sure that in case they were stopped by law enforcement personnel or otherwise, to try to, to have a letter on hand explaining the nature of their work and why they should be out on the roads, because there was some enforcement activity, especially early on with these stay-at-home orders. But the real critical question is this work that really needs to be done from an office? And I've advocated to my clients that just because we're going to make an exception under these world conditions today doesn't mean that we're forever saying no one has to show up to the work. Because I think that's what most employers are afraid of, is setting a slippery slope standard that that now we know it can be done remote. Are we going to let everyone work remote forever? And I don't think that has to be done either. I do think this pandemic will advance virtual workplaces. It will speed up technologically driven solutions to, other ways to work effectively and efficiently without having to physically be in the same space. The fact that Zoom and that my 7-year-old twins now know, like, oh, it's time to Zoom, or it's time to leave can I leave the meeting? Can I press leave meeting today? That's going to become ubiquitous in our society. And the fact that most of my partners, for example, didn't know about Zoom and its capabilities until the pandemic. I had been on a couple of boards that are national and have people around the country, and we had been using the technology for the last couple of years. And so I was much more comfortable with it, but it's amazing how everyone has sort of quickly come up to realize that this is a way that we can actually interact it's better than conference call. It's not as ideal as in person, but it's better than nothing.
Yep.
I have a question to follow up to what
Sure.
you were saying, and this is more from the employee side, so I don't know if you can answer, but I have a friend who's working for a company it's considered essential, and he expressed concerns because he has a pre-existing lung condition, but the company hasn't given him the ability, although everything can be done remotely except receiving mail and opening mail, I guess. His work could be done remotely, but they are not providing them, the employees, with options to work remote, nor masks or anything to help them work in a safer environment. What are his options? This is a Jersey office as well.
Whistleblower. Gonna be whistleblower at that point?
Yeah, I mean, I've worked with clients on developing a lot of plans, and it's funny how all of this has advanced so quickly. So about a month, 3 weeks ago, maybe a month ago, it seems like each week is a year. I was helping a client write a policy for, we're going to provide you with masks. You don't have to wear them, but if you want to wear them, we're making them available. We've paid for them for you, so we're not expecting you to go to any expense, but we're trying to, do our part to help. We have all these other social distancing rules. We're trying to keep people, to encourage them to wash their hands and not sit close to each other at lunchtime, but those are habits that are very hard to break, right? It's funny how, I drafted that policy, and then a couple of weeks later, it's sort of irrelevant because now everyone's being told if they're coming to work, they better be wearing masks, right? So I do have some employee clients who I've advised who themselves have immunocompromised conditions. I have one who, had a non-Hodgkin's lymphoma and, is fine today, but she had one of her specialists write a letter to her employer saying, this is not a time that this employee can be, and she was in a high contact with client type role, and in a essential business, in a healthcare related field. And, the specialist wrote a letter, and for now, the employer has extended sort of an unpaid leave of absence because she's run out of paid time off and other leave rights. Will that continue indefinitely? I'm not sure. But it's really hard. If a person is working, they should be given proper protections. I represent a lot of employers in dealing with labor unions, and I actually think that this is the moment when labor unions could actually start making significant inroads in representation, because there's a lot of employees who feel like they are not safe, or they have no security in how the way that their employer's operating in terms of job security. My discussions with employers about unions is that unions rarely form because employees are worried about their wages. It's usually about feeling like employees are not being treated with respect, or employees are worried about not getting honest communication and information, right? So I think that this is a moment in our world when labor representation is at an all-time low. But at the same time, I think if labor does the things right, then unionization will be on the rise, because if each individual employee doesn't feel like they have enough power to make a difference in getting change affected in the workplace, then they're going to turn to a third party. Does that help? I know it doesn't totally answer. The answer is that the employee should be noisy.
I guess what I'm hearing is what they should do and what they legally have to do is a little bit different. So, in this case, it's unfortunate that they're not doing what they could to provide a safer environment. But
I agree.
Well, did he get a doctor's note?
I don't think he went that far, because he had a conversation with his employer, and they basically said, look, we're in this together. that like everybody's coming, so there's no exceptions. And like I think hearing Jennifer's story about the other client that she has, and you know they offered options. These guys were not. This guy was not offered options. He could do his work remotely. I mean, I think it comes down. I mean, my advice to him was you need to find a different job. This is not somebody you want to work for. But that's, you know, during this time you don't drop what you have because you hold on to it dearly. But you know, maybe down in the future, maybe he'll consider, because obviously it's not an employer who's doing everything possible to provide a safe environment, especially in these times. These are. I mean, I hear what Jennifer shared about that employer, you know, doing the lunches and the masks and everything, and that's what everybody should do if they're in a if they're going to work. That's how it should be. You know, do everything you can.
Well, and you know, unfortunately, when I'm defending employers in litigation, I often start with no good deed goes unpunished, because, you know, as my theme, because oftentimes I've had so many cases with employers who try to do the right thing, and then a claim arises because they've tried to do the right thing. So, you know, one of the questions that was raised, and I don't know if the person who raised it is still on the phone or not, on the call or not, but about what level of information employers can ask their employees about in returning to work, right? I see Carla nodding her head. So if that's still of interest,
That was me.
it used to be that the standard was you don't really want to ask employees about anything that if they volunteer information, you're going to be empowered with knowing it, but you want to know as little as possible about employees' health conditions, their family life, all of those types of things, right? Here, we're in a little different world. First of all, the Equal Employment Opportunity Commission, the EEOC, has issued a lot of guidance over the last 6 weeks that, while it's not, some of it's about COVID-19 and some of it's more general, but it applies to pandemic type conditions. So it would have been applicable in the swine flu era and MERS and other types of conditions like COVID. And so a few weeks, about a month or 6 weeks ago, they started saying, yes, you could temperature check employees. That would normally be an invasive medical inquiry, but you could temperature check people before they come to work. Now, there was recently released guidance allowing employers to ask more questions about what have you been doing since you've been home, and who have you been exposed to, and have you traveled, and is there anyone you've come into contact with who's been exposed, and to try to minimize, keep their workplaces safe, because they're balancing obligations under OSHA, which is the Occupational Safety and Health Act, and also to make sure that employees coming into the workplace are not creating a direct threat to the health or safety of other employees, which is a basis under the Americans with Disabilities Act to keep people from working. So there's a whole lot of different tensions that employers really should try to do the right thing, but the right thing is oftentimes balancing a lot of competing interests. And so I have given a lot of different advice to different clients depending on the nature of their workplaces. I have one very large client with thousands of employees based in one building in one or two buildings across the street from each other in Philadelphia, where they're contemplating, before people return to work, doing staggering shifts, temperature checking everyone, safety gear, all these kind of things. Well, then there comes questions about, for people who are paid hourly, are they going to get paid for all that time that they're being safety checked to come into the office? And how long of a period of time are you going to have to allot for different people to show up and go through those procedures? And then that begs the question of, do we really need these people to come physically into the office? Or would it actually be easier to let people continue to work from home and just slowly stagger returns to work? And I think that there's going to be some hiccups as people start coming back to work. Employers are going to realize, wait, maybe this isn't the best way to get the work done. And if, say, 75% of the work could be done well from home, 75% is better than having these long lines of people waiting to be temperature checked and masked and everything before going into a workplace.
Yeah.
So I think it's going to be really fluid, but there's a lot, you know, if you have specific questions that you want to raise to me offline, I'm happy to discuss those with you. But generally speaking, there's a lot more that employers can ask today than they could ask even a month or two ago.
There's a lot that changed.
A lot has changed.
Thank you.
Yeah.
I have to jump off. I'm sorry, but I really appreciate it. Thank you.
Of course, I'm happy to help, and it's lovely to meet all of you.
Bye, Carla.
Yes, so we're over our hour. So if there's any other questions, I'm sure
I'm okay on time if anyone has any follow-up questions.
I have a question, but I can follow up with you separately because it's more of a non-compete type of being let go and
Sure.
signing a non-compete when I started. So I can ask now, or I can follow up by email.
Yeah, if you want to, whatever you prefer.
Rosemary, you want to end it, or?
are you comfortable talking about it on a recording?
Sure. I mean, it's not the specifics. It's literally, I signed a non-compete when I started at my previous job. I don't have any desire to go into a competition, but as a last resort, you know, if the right opportunity presents itself, I might consider. And I was let go because of the pandemic situation. So in situations where you're let go by the company and not brought back, would I be able to? I know non-competes are not as they're not as reinforceable, but still, I would want to know what the implications would be.
Sure. So I feel comfortable talking generally.
Generally, yeah.
Call, if that's okay.
Yeah.
But if you have specific questions, we can follow up separately.
Yeah.
Generally speaking, so there's a couple of types of restrictive covenant obligations there that employees could be asked to enter into from time to time. Non-competes are one of them, which stops you from working in a similar nature of business, usually either as to specific customers or in a specific geography. If it's a nationwide company, it could be a nationwide restriction, but those have to be really carefully scrutinized. I've even had clients that are subject to worldwide restrictions because of the nature of the business. There's also non-solicitation obligations, and those run as to both employee and vendor relationships as well as customer relationships. I think non-solicitation obligations are much more in need of being enforced, frankly, mostly than non-competes. The general rule of any of these is that you need to be able, an employer who's seeking to enforce one, and I do litigate, I advise on these a lot. I litigate both on behalf of individuals as well as companies looking to enforce, and also companies looking to defend against the enforcement. So this is, you know, an area that I spend a lot of time in. And generally speaking, where an employer has let someone go, then they don't have an ability to, they're going to be more challenged in their ability to prove that you working in a competitive way poses a competitive threat that is not consistent with law.
That makes sense.
Okay, so really, if they're not able to keep you because they don't have enough work for you to do, it doesn't seem right that you shouldn't be able to work somewhere else. And that these cases are all viewed in a sort of through a lens of fundamental fairness and in a court of equity, which is a lot about very fact-specific analysis and a lot of cost, benefit, risk analysis.
Mm. Interesting.
So, you know, every case is different. You could have the same fact pattern presented to two different judges and it might come out differently. So I give this as very general type of advice, but I think it is relevant to the pandemic that if an employee is under obligations not to compete, not to solicit, you know, in an ideal world, as you're being exited, that the extent to which those obligations survive should be addressed. If they're not addressed because of the situation we all went through, it might be prudent to put the former employer on notice of intent to compete and see if something could be worked out to avoid very contentious, very expensive, very emotionally draining litigation. But if that can't happen, a lot of employers are in, you know, survival mode right now. These cases are very expensive to litigate, both to enforce compliance as well as to defend against. So one analysis I gave to a client, an executive client recently, is your soon-to-be former employer really going to put money and resources into prosecuting your breach of this obligation?
Right.
Not a good use of resources today. Sometimes it might be said that, well, you have to enforce every single restriction because otherwise we could be, you know, faced with having to explain why we sought to enforce some and not others. I think that this pandemic is going to, you know, I'm involved in some of this litigation right now, and is going to cause all sorts of clients to reevaluate what positions they're taking in litigation.
Yeah. Thank you.
So thanks for that question. I think it is actually very relevant to these times.
Yeah. I almost want to say, if I was to, assume I was to join a competitor and then they would come after me, I'm like, use that money to hire me back. Why? You know, you say you don't have money.
I don't want to compete.
I don't want to.
Compete, right?
I don't want to. Exactly. And I hope that I don't have to.
And I will say, you know, you did say though, I'm not sure if these things are enforceable. They are enforceable. I mean, without looking at a specific agreement, it's hard to say, but they are enforceable. They are considered legal obligations that people enter into. You might not have had negotiating leverage to negotiate the scope, but they are enforced. And I've been able to enforce them on behalf of employers. I've also been able to, defend against them and sometimes keep them from being enforced, even though there's an obvious violation on its face.
Yeah.
Because it really goes to what is the competitive threat that the competition is creating.
Mm.
And if there's no business that your employer currently that your former employer currently has, then there is no competitive threat.
Right. Thank you.
Thank you, Jennifer.
Thank you. Unless Kathleen or Shelby has any other questions, I guess this can come to a close.
Yeah. Okay. Thanks, everybody. Stay safe.
You're muted, Kathy.
Great day. Hope to see you all.
Thank you for taking
I think Kathy wanted to say something.
today.
Oh, it was my pleasure.
Yeah, this is good. Thank you.
I'm so glad. I wanted to try to talk to about things that were relevant for all of you.
Yeah. Great job as always.
Thank you.
Thank you.
It's a pleasure to
Thanks,
meet you
ladies.
all.
Okay.
Bye.
All right, take care. Bye-bye.